Hi, welcome to MediatorPodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I provide valuation and divorce mediation services in St. Louis, Missouri. During this episode, we will discuss the divorce mediation process and the Better Apart method with Gabrielle Hartley. She is a leading divorce attorney, online mediator, and author of Better Apart. She's also a vice chair in the American Bar Association's dispute resolution section. And when she wrote Better Apart, Gwyneth Paltrow actually endorsed her book. But I think you brought up a couple good things in the book is how can we describe to people what is mediation and how is it even different than going to divorce court? Because if this is your first time getting divorced, you don't know. I don't know what the options are. I see TV and it says you go and fight in court. So how do we explain to them some of the differences?
So that's a really great question. And I take that probably for granted, having been a divorce attorney and mediator for 25 years. Mediation means you're going to a third party neutral who's not going to take sides. So for instance, if you were to hire someone locally or if you were to hire me online, the mediator is a neutral. We sit with you and we hear both perspectives. We gather the facts, and then the mediator helps you arrive at a resolution that works for your family. Now, mediation can be very passive. It can be very directive. You're in charge of that. But you do need to pick a mediator who's a good fit for you, because just like anything else, a mediator is not one size fits all, right? Now, if you're in mediation, I highly recommend you still get a legal consultation or 2 or 3 to know what your rights are, because nothing ruins a negotiation more than not getting advice and then at the end coming back and unraveling all of the work you did with your mediator. So really, like, an educated consumer is really the best customer. I think that's, an ad for NBO or some kind of men's clothing shop. But it's really true that if you don't know what you're entitled to, then you can't understand what you're giving up, and vice versa. If you don't know what you're looking at having to pay, you don't know if you're being generous or not being generous, regardless of how it may feel.
Yeah.
Sorry.
No. Keep on going. Sorry.
Litigation is the conventional Kramer versus Kramer kind of way forward. If anybody remembers that movie or has heard of it, it's like a cult movie from the 70s or late 70s. It is where you have an advocate, your spouse has an advocate, and they're literally adversarial bulldogs fighting. So that doesn't seem like it makes much sense for restructuring a family. If you have an impossible spouse who won't disclose or, is doing something untoward, absolutely litigation is necessary. I am not a mediator who is anti-litigation. I just don't think it's needed that often. Sometimes you may need litigation just to start the process, to show the other side that you mean business. It like lights a fire. And then you can come to mediation once one thing is filed and everyone gets their bills for $5,000 or $10,000 or $20,000. Like, oh, I don't need to do that. And then they come into mediation. But again, you need to know your rights. Litigation involves going to court for motions. Everything you want is typically arrived at in front of the judge. Your lawyers these days resolve a lot of things in the courthouse walls, but it's halls, not in the walls, in the halls. Help, let me out. But it's not a very dignified way forward if you can help it. You may do something called collaborative law, and there's collaborative law with a large C and with a small c. So collaborative law with a small c is what I really enjoy doing a lot, which is, in Massachusetts, I still do practice law, I still do family law, but people know when they hire me, I tell them, I'm not going to court, okay? So here's the deal, and I explain how the transition to a litigator will go, and that's all built into the arrangement. But they know that if anyone can resolve it at the table, I can, but I'm not a magician and I can't solve all problems all the time. So with a small c, the other lawyer knows, hey, once you file, I'm out of the case and you're going to have to deal with like a litigator who you're not going to like because I'm going to refer them to someone who's extraordinarily aggressive, right? So we can do this the easy way or the hard way. That's sort of how I play it, right? And so with the small c, we sit down at tables and we have an agenda and we talk it out issue by issue. And you need to have someone who's skillful about, knowing where to push and where to let go. Oftentimes, when you're negotiating, those low dangling fruits that people can agree to, when you start making agreements, that's going to start the harder things to fall into place. It's just like human dynamics. Now, I'm on a real roll here. Sorry if I'm going too long.
Great.
Collaborate with a large C is what people refer to as collaborative law. And Melissa, I believe you do collaborative practice valuations. Collaborative law is a program that was created and brought forward by Pauline Tesler and someone else whose name is escaping me, so I apologize if they're listening to you. You're agreeing not to go to court. You legitimately cannot go to court with the lawyers that you have, and those lawyers don't typically have a transition plan, whereas I would have a transition plan for the litigation. The rules of evidence don't apply, but it's sort of like a kinder, gentler way to move through your divorce with standardized meetings and to get agreements moving without wasting thousands and thousands of dollars in court. And when you go the mediation route or the collaborative route, you are more likely to come to agreements such as hiring a valuation expert or a financial expert jointly. While you can still do that at litigation, when you do it at the table, it's just more likely to stick and to help move things forward.